Where do you think you're going? Stop right there.
I'm headed to courtroom 4B. I'm late.
You don't just walk past like you own the place. What's in the bag?
Case files. Already cleared screening.
Doesn't look like it. Open it now.
I told you I cleared security. I have a docket in 10 minutes.
Open the bag ID.
You're looking at it. It's clipped to my belt.
Take it out.
I am the prosecutor assigned to 4B this morning.
That doesn't give you a pass to ignore.
He was carrying a case file, not a backpack, not a duffel bag, not anything that required a second glance from anyone operating in good faith inside a building they knew. A manila case file, the kind held together with a rubber band, thick with exhibits and witness statements, and the accumulated weight of months of prosecutorial preparation. The kind of file that, in a courthouse, is as common as marble floors and fluorescent lighting. He was also wearing a suit, a charcoal gray suit, white shirt, burgundy tie, pocket square folded with the precision of a man who understood that courtrooms are theaters and presentation is never incidental. He had a leather messenger bag over one shoulder. He had a security badge clipped to his lapels, the kind issued by the county, visible, legitimate, real. He was, by every observable measure, exactly what he was, a lawyer, going to court in a courthouse. And still, Officer Dennis Rourke stopped him, not with a question, not with a courteous professional inquiry, with a hand, flat palm, extended into the chest of a man who had done nothing to warrant it. His name was Damon Alcott, Assistant District Attorney, Fulton County, Georgia. 7 years in the office, lead prosecutor on a double homicide trial that was scheduled to begin in 4 hours. A trial he had spent 11 months preparing. A trial where 2 families were counting on him to walk into that courtroom and speak for people who could no longer speak for themselves. He had 47 minutes before he needed to be at the prosecution table. He spent 39 of them being interrogated in the lobby of his own courthouse by an officer who had decided, without a word exchanged, that Damon Alcott was not who he appeared to be. What followed those 39 minutes would trigger a federal civil rights complaint, a grand jury inquiry into courthouse security practices, a class action lawsuit that expanded to include 16 additional Black attorneys with similar experiences, and a settlement that restructured how Fulton County trained and supervised its courthouse security personnel. It would also nearly derail a murder trial because the prosecutor was almost too shaken to stand up. Before we continue, what city are you watching from? If this is your first time here, support the channel by liking and subscribing. Stories like this need to be heard, and with your help, we can make sure these events don't go unheard. Because what happened to Damon Alcott didn't happen in a store. It didn't happen on a plane. It didn't happen in a lobby where belonging is ambiguous and context is contested. It happened in a courthouse, his courthouse, the building where the law is supposed to live. You need to understand Damon Alcott before you can understand what was taken from him in those 39 minutes. Not his resume, his formation. He grew up in Vine City, Atlanta, one of those neighborhoods that the city's accelerating gentrification was beginning to consume even as he came of age. The old houses and corner stores being replaced block by block with the architecture of a different Atlanta, one that had decided to grow without its original residents. He watched it happen. He filed it away. He understood early that cities, like courtrooms, are governed by invisible rules about who gets to stay and who gets moved. His grandmother raised him, a woman named Cora Alcott, 71 years old, former school teacher, the kind of woman who enforced grammar at the dinner table and required that her grandchildren read 1 book a month and present a verbal summary on Sunday afternoons. She believed in the architecture of language. She believed that articulate, educated, precise Black people were a form of resistance. She built one. Damon was the first in his family to attend college, Georgia State on academic merit, pre-law. He was on the debate team, the mock trial team, and the student government simultaneously, not because he was trying to build a resume, but because he was building a voice, learning how argument worked, how evidence worked, how the truth presented badly loses to a lie presented well, and how his job, as he increasingly understood it, was to make the truth undefeatable. He graduated summa cum laude, Emory University School of Law, full scholarship. He turned down offers from 2 defense firms, good money, interesting work, and joined the Fulton County District Attorney's Office at 26. Not because prosecution was the obvious choice for a young black attorney in Atlanta. In some circles, it was the controversial one. He had the conversations, he had the arguments with friends, with mentors, with colleagues who questioned whether putting more black men in prison was the right form of service for a black lawyer. His answer was always the same. The victims are black too. He said it quietly, and he meant it completely, because the communities he came from, Vine City, Mechanicsville, the neighborhoods that the city's growth economy kept passing over, those communities were disproportionately harmed by violent crime. Those were the families that sat in the gallery. Those were the mothers who called the DA's office and waited and hoped that someone on the other side of the table cared about their child the way the defense cared about the defendant. Damon cared. In 7 years, he had tried 31 cases. He had a conviction rate of 83%. He had been named to the office's Major Crimes Division after 4 years, the youngest attorney in that unit's history. He had tried 2 capital cases and won both. He was known in the Fulton County Courthouse the way that exceptional people are known in the institutions they've dedicated themselves to. By the clerks who saved him good parking spots, by the judges who noted his preparation in their written opinions, by the defense attorneys who called him brilliant and formidable, in the same breath, usually while losing. He knew everyone in that building. Almost everyone, it turned out, knew him. Officer Dennis Rourke did not. Paint this precisely. The Fulton County Courthouse on Pryor Street is a building that carries weight, not just architecturally, but historically. This is where Atlanta's legal system breathes, where cases that have devastated families are argued into outcomes that are supposed to mean something, where the words justice and law are supposed to be more than decorative, supposed to be functional, operational, real. The main entrance security checkpoint is staffed from 7:30 a.m. Metal detectors, X-ray machines, court officers checking credentials and bags, standard courthouse procedure, attorneys, clerks, staff, witnesses, defendants, all filtered through the same narrow aperture of security protocol before the building opens fully to the public at 8 a.m. Most of the regular legal staff, the prosecutors, public defenders, clerks, judges, chambers employees, knew the officers by name. The relationship was collegial, professional, the kind built by years of shared institutional space. Damon entered through the attorney's entrance at 7:48 a.m. He had his badge visible, his messenger bag on one shoulder, his case file under his arm, his phone in his hand. He was reviewing a text from his investigator about a last-minute witness statement issue that needed resolution before the trial began. He walked toward the security checkpoint. He placed his bag on the belt. He walked through the metal detector. No alarm. He picked up his bag on the other side. He was moving toward the elevator bank when he heard it. Hey, you, stop. He turned. Officer Dennis Rourke was new. Not new to law enforcement, 14 years on the job, formerly with DeKalb County, transferred to the courthouse detail 6 weeks earlier. New to this building, new to these faces, new to the particular ecology of a courthouse where everyone has a role, and the roles are visible if you pay attention. Rourke was not paying attention, or rather, he was paying a very specific kind of attention. He was paying attention to Damon Alcott, not to the badge on his lapel, not to the attorney's entrance he had used, not to the case file under his arm or the security checkpoint he had just cleared, not to any of the contextual information available to anyone operating in good faith. He was paying attention to Damon, to the man, to what he saw when he looked at him, and what he saw apparently required investigation. Rourke crossed the lobby in 6 strides. He was a large man, 6'3", built like someone who had played football in a previous chapter of his life and kept the frame without the conditioning. He moved with the particular energy of authority that hasn't yet learned restraint. Fast, forward-leaning, chin slightly elevated. He stopped 2 feet in front of Damon, closer than protocol, closer than courtesy. Where are you going? Damon looked at him. processed the approach, processed the proximity, processed everything. The way black men in these situations are required to process everything simultaneously, running calculations about survival and dignity and consequence in the time it takes another person to draw a breath. He said, "I'm going to my office. I work here. I need to see some ID." Damon's badge was on his lapel, visible in plain sight, the kind of credential that, in a courthouse, answers the question before it is asked. He touched the badge with one finger. "This is my county-issued identification. I need a government-issued photo ID." Damon paused. "I just cleared security. I'm asking you for photo ID." On what basis? Rourke's jaw tightened. That particular tightening of a face when authority is questioned by someone it expected to fold. "Sir, I'm not going to explain myself. I need to see your ID." Here is what Damon Alcott understood in this moment. Understood with the clarity of a man who had spent 7 years inside the machinery of law enforcement, who knew probable cause standards and Terry stop requirements and the Fourth Amendment jurisprudence that governed exactly this kind of encounter. He had done nothing. There was no articulable basis for suspicion. There was no reasonable inference of wrongdoing. He had entered through the correct entrance, cleared the correct security checkpoint, was displaying the correct credentials, and was walking toward the elevator in the correct manner of a person who worked in the building they were standing in. There was no legal basis for this stop, none. He also understood something else, something older and heavier than the law, something that lived in the body before the brain could analyze it. He understood that being right wasn't always protection, that knowing the law didn't always mean the law would protect you from the person who was supposed to enforce it. He reached into his messenger bag. He produced his Georgia driver's license. He held it out. Rourke took it. He looked at it. He looked at Damon. He looked at the license again. And then, and this is the moment where the situation detonated, he said, "What's in the file?" The file, the case file that Damon had been carrying for 11 months. The file containing exhibits, witness statements, autopsy reports, police records, chain of custody documentation, and the prosecutorial strategy for a double homicide trial starting in 4 hours. Confidential, privileged, protected under attorney work product doctrine. The contents of that file were not subject to inspection by a courthouse security officer under any protocol, not for attorneys entering through the attorney's entrance, not under any policy that Fulton County had written, reviewed, or authorized. Rourke didn't know that or didn't care. Damon said, "That file contains privileged legal materials for a trial beginning this morning. You don't have authority to inspect it. Everything coming into this building is subject to inspection. Not privileged attorney work product. That's protected under..." "Sir, I'm going to need you to lower your voice." Damon had not raised his voice. He had not raised his voice once. His tone was level. His words were precise. His body language was contained in the way that black men in these situations are required to contain themselves. The constant, exhausting, invisible labor of compressing legitimate anger into the narrow space of what is safe. But here is what was happening in the lobby while this exchange was occurring. People were watching. A court clerk named Rashida Burke, who had worked in the Fulton County Clerk's office for 9 years and who knew Damon Alcott well enough to know his coffee order and the names of his lead investigators, had stopped on her way to the elevator. She was watching with an expression that she later described to investigators as disbelief that curdled into fury in real time. A defense attorney named Carl Whitmore, who had faced Damon across the prosecution table 4 times and respected him as much as he fought him, was standing at the security checkpoint. He had seen the interaction from the beginning. He had seen the badge. He had seen the case file. He had seen Rourke approach and the proximity and the jaw and the demand for documents that were already visible. He pulled out his phone. He did not announce that he was recording. He just started recording because Carl Whitmore was also a black attorney, and he had been stopped in this lobby before. What followed was not a brief misunderstanding resolved by a quick explanation. It was 39 minutes during which Rourke having taken Damon's driver's license and his county badge, radioed for a supervisor. The supervisor, a senior officer named Sergeant Marcus Webb, took 11 minutes to arrive. During those 11 minutes, Damon Alcott stood in the lobby of his own courthouse, his credentials held by an officer who had no lawful basis for detaining him, watching the clock move toward a trial he needed to prepare for. He called his office. He told his paralegal, a woman named Keisha, what was happening. Keisha said, "Are you serious right now?" He said, "Please let Judge Abernathy's clerk know there may be a delay." He ended the call. He stood. He waited. Sergeant Webb arrived. He looked at the situation. He looked at Rourke. He looked at Damon. He looked at the badge in Rourke's hand, the county-issued badge with Damon's name and title, and the seal of the Fulton County District Attorney's Office, and something moved through his face that was not quite embarrassment and not quite alarm, but lived somewhere between the two. He said to Rourke quietly, "Where did you say he came in?" "Attorney's entrance." "And he cleared security?" "Yes." "And that badge, you pulled that from him?" Pause. "He presented it voluntarily." Webb looked at the badge again. He looked at Damon. He said, "Mr. Alcott, Damon said, "Before you say anything, I need you to understand that I have a trial beginning in 4 hours. I have been detained in this lobby for," he checked his watch, "22 minutes. I am a licensed attorney, an assistant district attorney for Fulton County, and I cleared your security checkpoint correctly with valid credentials. I need my documents returned to me now." Webb turned to Rourke. Rourke said nothing. Webb held out his hand. Rourke placed the badge and the license in it. Webb handed them to Damon. Damon put them in his pocket. He picked up his case file. He walked to the elevator. He pressed the button for the 5th floor. He stood with his back to the lobby and waited for the doors to open. And in the 39 minutes it had taken to resolve a situation that should never have existed, 2 families had lost 19 more minutes of believing that justice was coming. And Damon Alcott had lost something that no elevator ride would fully return. Carl Whitmore's recording was 3 minutes and 41 seconds. He had captured the core of the exchange: Rourke's demand for the case file, Damon's invocation of attorney-client privilege, Rourke's instruction to lower his voice when his voice was already low. He had captured Sergeant Webb's arrival and the particular geometry of the moment when a senior officer understood what his junior had done and couldn't quite find the language for it. He texted it to Damon that afternoon. After the trial's opening statements, Damon didn't post it. He sent it to his attorney. His attorney sent it to the Georgia State Bar Association, the Fulton County DA's office leadership, and the American Bar Association's Commission on Racial and Ethnic Diversity in the Profession, all in the same email. Then she sent it to the Atlanta Journal-Constitution. The AJC published the story 48 hours later, not just the video, but a full investigative piece. Because here is what the reporter, a woman named Dana Osei, who covered the courts beat, discovered when she started making calls. Damon Alcott was not the first. He was not the second or the third. He was, as far as anyone had documented, the 17th. 17 black attorneys, prosecutors, public defenders, solo practitioners, partners at firms who had experienced some version of what Damon experienced in the Fulton County Courthouse. Stopped, questioned, detained, asked for credentials beyond what white colleagues were asked to produce, treated as if their presence in the building where they worked required an explanation that their presence should never have required. 16 of them agreed to be named. 16. The class action lawsuit filed 3 months later represented all 16, with Damon Alcott as lead plaintiff. The complaint was 104 pages long. It detailed dates, times, officer names, specific interactions, a forensic catalog of a pattern that had been operating in plain sight in the Fulton County Courthouse for years without institutional correction. It also named something specific in its allegations. The security detail had never received formal training on interacting with attorneys. None. Not the attorney's entrance protocol, not the privilege protections governing case files, not the credentials issued by the county to its own legal staff. not the basic principle that a person who has cleared a security checkpoint and is displaying valid institutional credentials is not a subject for further interrogation without articulable cause. 7 months of Dennis Rourke's previous assignment in DeKalb County. Nothing in his courthouse orientation about any of this. He had been put in a courthouse with the same training he'd had for a parking enforcement detail. And when his assumptions filled the gaps, as assumptions always do when training is absent, a black prosecutor was standing in a lobby explaining himself in a building that existed to pursue justice, because we have not yet spoken about the trial, the double homicide, the 2 families, Keandra Williams, 24 years old, shot outside a convenience store in Mechanicsville, mother of a 2-year-old daughter named Ava. The kind of death that happens so regularly in certain neighborhoods that it risks becoming a statistic, which is why Damon Alcott had spent 11 months making sure it didn't. Terrence Obi, 19 years old, caught in the same shooting, had been walking to a bus stop, had been in the wrong place at the wrong time in the specific way that means you were somewhere ordinary, and ordinary became fatal. His mother, a woman named Grace Obi, had driven 2 hours from Savannah to sit in that gallery every day of trial. Damon had met with both families. Multiple times, he knew Ava's name. He knew that Grace Obi couldn't sleep. He knew the weight of what he was carrying into that courtroom. He carried it in while still shaking, not visibly, not in a way that the jury could see or the defense could exploit or the judge could note. But his paralegal Keisha saw it. She saw it in the way he set his case file on the prosecution table with more deliberateness than usual. She saw it in the 2 minutes he spent with his hands flat on the table before he stood for opening statements, a stillness she had never seen from him in 7 years. She asked him afterward, "Are you okay?" He said, "I had to be. That is the cost that no lawsuit recovers, the 39 minutes that no settlement restores, the shaking that he had to contain because 2 families were counting on him and he could not afford to bring his humanity into a courtroom that was designed to render humanity in the service of argument. He won the case, both counts, first degree. The defendant was sentenced to life without parole. Grace Obi thanked him in the hallway outside the courtroom. She took both of his hands in hers and she said, "I knew you would fight for them." She didn't know what had happened that morning. He didn't tell her. Some things you carry without sharing, because the carrying is also part of the job. The numbers, when they came in layers. Fulton County settled the class action lawsuit 14 months after it was filed. $8.4 million distributed across the 16 plaintiffs with Damon Alcott as the lead, his portion reflecting the documented severity and the trial day impact on official proceedings. The settlement also mandated the following, and read these carefully because this is where individual accountability becomes structural change. Mandatory courthouse-specific training for all security personnel. Every officer, every supervisor covering attorney credentials, privilege protections, the legal framework governing attorney-client materials, and the procedural standards for any interaction with court officers. Not a one-time module, a recurring annual certification. The installation of a formal complaint and review system for attorneys reporting discriminatory treatment in courthouse security interactions, independent of the security chain of command, reporting directly to the county's Civil Rights Compliance Office. A demographic audit of all security interaction reports from the preceding 5 years, documenting race, credential type, and outcome, submitted to an independent monitor with authority to flag patterns and require response, and the provision that courthouse administrators had resisted most strenuously and that Damon Alcott's attorney had insisted upon most firmly, a mandatory review board for any security stop of a credentialed legal professional that lasts longer than 5 minutes. 5 minutes. Because 39 shouldn't happen, and if 5 are happening, someone in authority needs to know. Dennis Rourke was terminated. His termination occurred not immediately, which drew its own criticism, but following the internal investigation's conclusion, which documented that his interaction with Damon had violated 7 separate provisions of the Courthouse Security Code of Conduct. His written explanation for his actions, submitted during the investigation, read in part, "I did not recognize the individual and felt the situation required verification. He did not use the word race. He did not need to. The pattern, documented in 104 pages, said it for him. The Georgia Peace, Officer Standards, and Training Council, the body that certifies law enforcement officers in the state, opened a separate proceeding. Rourke's certification was suspended pending retraining. He was required to complete a 30-hour course on constitutional standards for stops and detentions before any reinstatement could be considered. The ABA's Commission on Racial and Ethnic Diversity in the Profession published a formal report using the Alcott case as a primary case study, recommending that courthouse security across the country implement specific attorney recognition protocols and bias response procedures. The report was distributed to bar associations in 38 states. 38 states, because this wasn't just Atlanta, this was everywhere. There is a particular cruelty in what happened to Damon Alcott that goes beyond the 39 minutes in the case file and the shaking hands on the prosecution table. It lives in the location. A courthouse is not a neutral space, it is a space built around a promise. The promise that the law applies equally, that the institution exists to serve justice without regard to the identity of the person standing before it. It is, in its ideal form, the physical embodiment of the principle that no one is above the law and no one is beneath its protection. Damon Alcott spent 7 years serving that promise. He walked into that building every day, carrying the weight of victims who needed someone to believe that the promise was real. And in his own courthouse, the building that was supposed to be the promise made manifest, he was stopped, not by the law, by the assumption underneath the law. The assumption that a black man carrying a case file in a courthouse is more likely to be questioned than guided, that credentials visible to the naked eye require verification beyond what they contain, that belonging, in the place where belonging should be most protected, is still conditional on something beyond what you carry and what you've earned. Here is the rhetorical question that this story forces into the open. If a black prosecutor cannot be recognized as belonging in a courthouse, in his courthouse, where exactly is the space where that recognition is automatic? Where is the room, the building, the institution in which a black professional's credentials are accepted without suspicion and their presence is welcomed without interrogation? Is there one? Is there a single professional space in this country where excellence and achievement and documentation and years of service are sufficient, where the math simply works and the answer is belonging? Or is the credential always on trial? Is the person always the first exhibit? And what does it cost? Not in dollars, not in settlements, but in the human being, the daily accumulation of having to prove yourself in the space you built, to the institution you serve, to the system you fight for. What does that cost? What is the compound interest on a lifetime of it? When Carl Whitmore's recording surfaced and the AJC story ran and the phone started ringing, when black attorneys across Atlanta began to hear the story and recognize it, something happened that the institution had not anticipated. They talked. 16 of them came forward formally, but dozens more called, sent emails, left messages with the attorneys working the case, stories that range from the relatively minor extra questioning, requests for additional identification, the prolonged hover of an officer who kept finding reasons to remain nearby, to the severe, a public defender who had been physically blocked from entering her own courtroom, a partner at a prominent firm who had been asked in front of clients whether he was sure he was in the right building. All of them black, all of them lawyers, all of them navigating a system they had dedicated their professional lives to serving and being treated by that system as if they were suspects first and officers of the court second, or never. What emerged from those conversations, from the depositions, from the investigations, from the conversations between black attorneys who had never compared notes on this before because there had never been a mechanism For comparison, was the portrait of a structural failure so thorough and so consistent that individual bad actor collapsed as an explanation under the weight of the evidence? Dennis Rourke was not an anomaly. He was a symptom. The absence of training was not an oversight. It was the environment, and the environment had been quietly telling Black attorneys for years in the building where justice was supposed to live. You have to earn your way in. Every day, prove it again, and again, and again. Damon Alcott still works in that courthouse. He takes the same attorney's entrance every morning. He presents his badge, the same county-issued badge that Dennis Rourke held in his hand like it was evidence rather than identification, and he walks through the same security checkpoint. He knows some of the officers now. They know him. The ones who came after the settlement, who went through the training, who were given the protocol they should have had from day one, they greet him by name. "Morning, Mr. Alcott." He nods. He keeps moving. He has a case to prepare. There is a version of this story that ends there and calls it resolution. The training happened. The settlement was paid. The policy changed. The building is different now. And it is different. But here's what doesn't change with a policy. The morning he was stopped, Damon Alcott was carrying 11 months of work for two families who had lost everything. He was 47 minutes from a trial that would determine whether the people responsible for two deaths would face accountability. He was standing in the building where he had given 7 years of his professional life in service to an institution that was, in that moment, failing him with the full weight of its indifference. And he had to stand there, composed, precise, professional, not because it felt right, not because it was fair, but because the alternative, the anger, the grief, the legitimate human response to being treated as a threat in the place where you fight for justice, was not available to him. He couldn't afford it. He had work to do, and that is the sentence that should echo longest. Not the settlement, not the policy, not the termination of the officer or the restructuring of the training program. He had work to do. He had always had work to do. He went in and he did it, while carrying everything they had put on him, while carrying everything they couldn't see. He walked into that courthouse to fight for justice. They questioned whether he belonged there. He went upstairs and proved in a court of law that he did. But the question that survived the verdict, the question that no gavel closes, why in the building built for justice, was justice the one thing he couldn't take for granted? That question lives on the 5th floor, in the lobby, in every courthouse in this country, in every room where the law is supposed to mean something, and the person serving it still has to fight to get through the door. Drop your city in the comments. I want to know where you're watching from and what this story is bringing up for you, because this one hits different. If you know a lawyer, a prosecutor, a public defender, anyone working in law, send this to them. They need to see it. They probably already have a story like it. Hit like, subscribe, and share this before the algorithm buries it. Next week, we go into another case that powerful institutions tried to contain, and we're going to make sure the world hears it. Stay locked in.